It's still on. Lift notification. I have a ride home in case I get tarred and feathered. Thank you. We've still got a minute or two. Hi, Che. All right. Ladies and gentlemen, it's 2 o'clock. If there's anybody out in the hall, come on over and join the party. All right, seeing none, I'm going to call this meeting to order. March 7th, 2023 at 2 p.m. Can I get a roll call, please?
Commissioner Briley?
Here.
Commissioner Baugh?
Here.
Commissioner Byers?
Here.
Commissioner Michelina?
Here.
Commissioner Richardson? Commissioner Rigsby?
Here.
Commissioner Williams? Also present is Stephanie and Samantha for the Community Development Department and Zach Cook, Village Attorney. You do have a quorum.
Fantastic. We have 100% attendance, not only a quorum. So, gentlemen, if you care to sign in, please. Conflict of interest declaration. As I state on the beginning of most of these items, my primary employer is the Highway Department, the NMDOT, and so anything on Sutter to Meacham, I will have to disclose that I will be commenting on behalf of the department, not necessarily on behalf of the village. So my primary job comes first for the next 2 months. So I also want to state that item 6F, case CU 2023-30, I will be abstaining. I have interests in both the owners and the property managers. Anybody else have any conflict of interest? Certificate of compliance, please.
I do certify that the meeting and all of the properties were posted in accordance with Resolution 2301 and with Section 5440 of the Municipal Code.
Thank you. So we have quite a lengthy agenda. Does anybody wish to make any changes to it, amendment? If not, I'll take a motion to approve.
Make a motion to approve the agenda.
Second.
We have a motion and a second to approve the agenda. All those in favor say aye.
Aye.
Aye. Noes? Approval of minutes. It's quite lengthy. We had a good meeting last month, and I think that most of everybody's comments were taken. Does anybody have any comments or adjustments or revisions to the minutes? Seeing none, hearing none, can I have a motion to approve the minutes?
Mr. Chairman, I'll make a motion to approve the minutes as submitted.
I second.
So that's an approval of the minutes for February 7th meeting. And a second, roll call, please.
Commissioner Baugh?
Aye.
Commissioner Briley?
Aye.
Commissioner Byers?
Aye.
Commissioner Michelina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Abstain.
So with the approval of the minutes, last meeting, they had a vote for the chairman and vice chairman, and I was voted out. So, but Commissioner Rigsby is voted in, and he's by Zoom today. So he asked me if I would take this meeting, since a couple of the items were from last month anyway. So I'm on my way out the door at the end of April. So this meeting and one more. So public input. So this is the part where anybody can say anything to the Planning and Zoning Commission, any comments and any questions that is not on the agenda. Any items that are not on the agenda is fair game for us to listen to right now. Anybody? Anybody online? Hearing none, we'll go to the next item. Okay, these are our public hearings. A continuance of petition for rezone case RZ 2023-1. Glenn Remington. This is a continuance. We've already had public hearings on this. I will probably allow a little bit of comments if it's nothing new that hasn't been read into the record. Sam, do you want to take the summary, or you want Samantha to? Or Zach?
Samantha will take the summary. So with us today, we do have the applicant, Glenn Remington, presenting his petition to rezone to an R2. Did you want to allow him? It looks like he has renderings to display.
So before we go on to this, as I stated, everybody's comment has been read into the record for the public hearing. This is something that our commission had an executive session and came out of executive session saying, we're not quite understanding what the applicant wants to do. And second of all, we hear a lot of testimony about emotional, and my grandfather this, my whatever said this, and nothing to, I guess, state the fact of law to us of why we shouldn't. So I'm going to allow the applicant to give his presentation of what he wants to do with this property, and then I'm going to allow the people that may be against this, given a short amount of time each, just to state why we can't approve his request by law. And so those are the things I am requesting from the audience. I know that there's a lot of people here to speak for and against this, but we have heard this through public hearing already. So Mr. Remington, can you come down and kind of give the commission an idea of what you want to do if this case is rezoned as you have requested? And I am still going to ask to swear you in. Do you swear to tell the truth, nothing but the truth? Glenn, give us a presentation of what your ideas are for this property that you want to rezone.
Everybody got to look at it. Stephanie said she could, oh, there it is. So this is one idea. Those are duplexes. They're about 1,600 square feet. There's a garage in between the units. Each has a double-car garage. Density is below what we would be allowed for that amount of acreage. It computes to maximum density of 16 units, and there's only 11 there. Our village attorney tasked us to go to the ordinance to find our argument, and I didn't have to read very far. The rezoning ordinance states that these changes in zoning classification are for the purpose of meeting the land use needs of the residents of the village in conformance with the village comprehensive plan. Now, we must be in line with a comprehensive plan, otherwise I don't think that your staff would be in favor of the rezone. So basically, apparently one of the problems last time was my ambiguity. That's why we did this. So that's all I got to say.
Thank you. Samantha, on this tract, is what he's saying that is maximum 16 units are allowed on this, 1.8 acre tract?
So the code says not more than 9 dwellings per unit, 9 dwellings per acre. So that would be okay, but whenever you get to the multifamily dwellings, townhomes, and apartments, he's not allowed more than 4 units as it's currently subdivided for Lot B1.
Thank you. So I was advised that I can reopen the public hearing for comment for the record. So I'm going to do that now. I'm going to reopen the public hearing for this case. Does anybody wish to speak for or against this case? And as I stated, we would sure like for people to comment on why the law says we should not pass this. Come forward, identify yourself, and let me swear at you.
Thank you. My name is William Griffin.
Swear to tell the truth, nothing but the truth.
I do.
Thank you.
Thank you very much. I'll tell you all that what I told you last time. I'm an attorney here in town. And I decided that today, because I've been through the process a number of times with judges, people who judge our conduct, our delivery of the law, and they don't like being told that there is a specter or a dark cloud of appeal hanging over their heads. It seems to rub people wrong. But I think it's appropriate in this instance for me to walk you through what we consider to be appellate grounds, because it would be prudent to consider them as they would be our grounds for an appeal. And so with the help of some of my clients, we sort of compiled the important points that we think both were mentioned by Mr. Cook. What do we need to do and what you've mentioned as far as the law is concerned? And I differ strongly with Mr. Cook in his interpretation of the Miller versus City of Albuquerque case. He said that was under specific circumstances. And I know that across these United States, there are a number of jurisdictions that adhere to McQuillan's Law of Municipal Corporations, and most specifically, Section 2572. It says exactly what the Miller versus City of Albuquerque case says. Before property is classified from one zone to another, there must be proof of either. And may I back up and tell you, we're talking about rezoning, and I know that's what this topic is today, but that's what this specifically addresses. Before property is reclassified from one zone to another, there must be proof of either one, that there was a mistake in the original zoning, or two, the character of the neighborhood has changed to such an extent as to justify rezoning, and that public need exists for rezoning. So let's break that down a little more. If it was a mistake, what should it probably look like? I bet it was a mistake to call it R2 when there is R1 structures. That would be a mistake that we could spot and say, why do we have it classified as R2 when everything in there is R1? That's the kind of mistake I think that both McQuillan on municipal corporations and the Miller versus City of Albuquerque case states that you have to show that there was a mistake, and that's why you would do the zoning. It's prudent to do a rezoning because it makes sense. There's a mistake. And the other one is such a change in the circumstances in the neighborhood. I'm dealing with this in a number of different cases, and we've gone pretty darn deep. And there are some cases right here in Lincoln County, including the Palmer versus Cree Meadows case, that talks about how land is dedicated in a certain way. People buy up around it, and they have their expectations, and they know what those expectations are. But if those things change, let's say everybody puts a single wide trailer in a neighborhood where they're totally forbidden, we could say, you know what, we're going to allow single wide trailers. Well, that's probably a bad example, but that's what I'm dealing with, unfortunately. But a better example for you guys would be, under the circumstances, what does the neighborhood look like in there? Are we looking at the best piece of developable property in Green Meadows? No, I think the fact remains that since 1961 it's not been developed because it's a wooded ravine. It's inconvenient for construction. It's not very conducive to residential construction. And the folks who had built and bought around there bought into single residential, R1, single-family residential homes. So it's an important distinction that we make. Sure, and I may be using up my time already, but Mr. Cook said, your only concerns are 5432, your own ordinance that says, what should we consider? And my clients suggest that there are some pretty important considerations. In 5432, it's 3, 4, 5, and 7 that we look at. Things like ensuring adequate light and air for all properties. If you have additional properties or additional density on the property, that doesn't satisfy it. Preventing the overcrowding of land and undue concentration of population. Again, that's the kind of thing where if you increase density, you're going against your own ordinance. Facilitating adequate provisions for transportation, water, sewer, schools, parks, other public facilities. We've pointed out, and we will when we talk about Green Meadows Drive, that it's too small. It wouldn't accommodate fire vehicles. But that ravine is a serious, serious issue. And if you've not been out there, I would seriously recommend to any of you to go out and see what it looks like, that last little bit of Green Meadows that never got developed. I'm not going to drone on too long about any of these other things, but I think it is important to consider, take those two main considerations that come from case law and take into consideration that there's a substantial group behind me with significant interests at stake. They've got property interests at stake. So they're interested in spending money potentially to oppose this. They've spent money to bring me here, and I have 3 minutes to try to do it. But I'm telling you, take more than 3 minutes of your own time. Take a serious look at whether or not there's been a mistake, and this represents a mistake. This particular image is, gee, we should have done this a long time ago. I don't think that's quite true. And has the neighborhood changed so much that we can now say R2 is appropriate in this neighborhood? Would we do that for the public good? I think that, sorry to do this to you. I'm going to apologize before I'll apologize in the back end of it and just say, nobody likes to be appealed. But what I learned is that when somebody points out to you what your opponent points out to you what your potential appellate grounds are, you might want to write them down and go home and secretly look them up and see if there might be some truth to that. Take a look at McQuillan's Municipal Corporations, sections 2572 particularly, that speaks about this very issue about rezoning. And you'll note that many states from which New Mexico takes its lead for its statutory provisions, New Mexico is not the only state to have case law interpreting McQuillan's provisions to say that you have to either have a mistake in the zoning or you have to show a substantial change in the neighborhood condition. And I don't think that Mr. Remington, very respectfully, has either shown either of those two things or any of the elements of 5432, which would facilitate your decision to rezone for him. Thank you.
Thank you. Is there anybody else that wishes to speak for or against this item?
Mr. Chairman,
Man, Mr. Rennick, you were like third in line from stating your voice, so let's.
that's fine. I don't have a way to raise my hands when you get to me.
Okay,
just let me know.
you're third in line, Che.
All right.
Okay, come forward. State your name and swear to tell the truth, nothing but the truth.
Larry Forsyth, yes, sir, I do.
Larry, thank you.
I watched the meeting last time on Zoom. I'll try not to give you any emotions, though I know it's a very emotional thing for this. Can I have this in the record, please? May I approach?
Yes. Come on.
Thank you, sir.
Thank you.
And you're going to read all this to us in 5 minutes, right?
Only the highlighted part. Exhibit 1, it says that you didn't think it was improper, it was proper to have R1 changed to where it would R2. So we wonder why we're here. Exhibit number 2 is the two different subdivisions. The red is the Woodland Ridge, which is where the village is saying, well, there are some R2 in there. And the green is Green Meadows, which says only single-family homes. Now, went over to Lincoln County, and I pulled the subdivision stuff for Woodland Ridge. And it is true that they initially had the yellow highlighted areas that are there as multifamily. But they caused such a problem that in 1983, all the lot owners, or at least 51% of them in Woodland Ridge, changed their code or covenants so that only single-family homes could be built. Now, I've already, last time, I think they provided you with the call sheets for police routes at the apartments. And anytime you start putting in, what do you call it, workforce housing, Section 8, whatever, you're going to have more police calls than you have in a normal neighborhood. That's just the facts, and I think that what we presented last time showed that. Number 4 is nothing more than the covenants, but the second page says no single-family dwellings shall be permitted on any lot in there. We hear a lot about that the village doesn't enforce covenants. And I know this is not germane, number 5, to this meeting, but this is what yours says about the short-term rental. And it's very clear. It says that y'all will not enforce it, and it will be left up to the eligible neighborhood. But look at number 6. It says, and this is under your zoning, conflicts with local ordinances where the provisions of any local ordinance or covenant impose greater restrictions than those of this article, the more restrictive provisions shall prevail. Doesn't say anything about who's supposed to enforce them. This is a code that reads to you, that reads to me, and it'll read to anybody. Number 7. You're going to put those duplexes down there, and you're going to put in this report that it won't affect the property values. I don't see how you can possibly do that. We don't know if they're going to rent, they're going to sell. You're going to have the same problems that you normally have with duplexes and apartments. You have people out there working on their cars, you have people out there standing around drinking, and you're wanting to put that in the middle of a peaceful neighborhood that has only single-family homes. Number 8 has absolutely nothing to do with this. It's just a little bit of levity. I thought we used it. I found this when I was researching. I went back to make sure all these covenants covered. This is where Wingfield got his United States patent for this lot, or property that he owned. And can you imagine him going from the land office in Roswell to Ruidoso in his 25 Model A, what the roads would have been like? Oh, one other thing. When you get your covenants, the originals that you have don't have that. They stamp it on there now that you can't use any type of restriction that would be for handicapped or status or people's race or whatever. If you pass this and you open this Pandora's box of where you can go into a neighborhood and change the covenants, who's going to be responsible for telling the buyer, the real estate agent, the title company? Are we going to put a stamp on there that's saying, well, with one stroke of Samantha's pen, your covenants are no good? Anybody have any questions for me?
Thank you very much. And I want to remind everybody, being this is quasi judicial, you have the right, both applicant and the people testifying have right to cross-examine as well. So Glenn, at the end of testimony, we'll have you, if you need any comment back. Go ahead, come back, come forward. You may come forward. Come downhill.
Dana Lenzo, yes, I swear the truth, 202 Keys. Couple of things. I was confused by the statement by Mr. Cook about to look in the NMSA 5432/8. And I was looking in the NMSA, only it's not in the NMSA, it's in the Ruidoso Village Ordinance. So that was not clarified in the notes. In the meeting minutes, it's swearing Jin with G-I-N. It was my mother's father-in-law, not mine. Those are your corrections that I noticed in my section alone. Where to start? Okay, so I found 5432 after going online and looking at the online draft minutes today, and I found where we were looking at, so henceforth it didn't give me a lot of legal time. What it did give me was time to point out that if you built Lincoln Towers in Kevin Key's front yard, from my house, Lot 2, Block 9, I would be looking straight out on the roof of Lincoln Towers. The elevation change is such that you could put a 4-story building on 5th Street, and from Mr. Senna's yard, you would barely be looking over the top of it. So, elevation changes go about in such a way in this end of the property that the picture that you were given in your stuff is an inappropriate representation of the actual geographical nature of the property that you're looking at. I have pictures that I'd like to give you that I have notated on actually y'all's paper that have the elevation changes. So do you want me to hand these to you? Okay.
You have a copy for everybody?
I don't.
It's okay, we'll pass around real
It's
quick.
a slow thing.
And it will go to Stephanie for the record.
Yes, please. So if you look at dot A, that is in the middle of Green Meadows Drive, where we had originally been approved for vacation of right-of-way back in 2010. That elevation from there down to the front of Kevin Key's house is 40 feet vertically. Picture A and picture B are taken from a marker by the village in the middle of the Green Meadows Drive, looking in 2 separate directions. In the second picture, if you look across, you can see all the dirt that was brought in with dump trucks from the hospital property. The second picture is taken from the corner of Kevin Key's property down off of 5th Street, looking up the draw, so you can actually get a glimpse of the 40-foot elevation change, which is in the middle, which coincidentally is right where the back of one of his properties would be. So you're looking at a 30 to 40-foot adding in of property to make a garage able to be driven in that area. When you look at the last picture, picture D, that picture is taken at the end of Apache Hills, looking actually out into the drainage area, not off to the north where it is relatively level. So henceforth, those pictures show that what you guys got entered into your property was not a real actual representation, which is why, again, with the nature of housing that we need for the service industry in this community, I strongly encourage you to walk the property. Take a look at it, because these are the people that we're wanting to build housing for. These are the people who don't have the money to replace it, and these are the people, when the 4 feet of water goes washing through with Hurricane Dolly, are going to be paying the cost if we're using substandard materials.
Thank you. Thank you for the pictures. We'll put them into the record. Charles Rennick, I have you next in line.
Thank you, Mr. Chairman. It's good to see you again.
Yes, sir.
I've not been sworn yet.
Do you swear to tell the truth, nothing but the truth?
I do.
Thank you.
Thank you. I'll try not to repeat what the others have said. Mr. Griffin expertly presented the law to the commission. I do want to respond to one question that Chairman Briley had, which was at the beginning of this hearing from the opponents, why shouldn't we grant this request? With all due respect, I'd say that's the wrong standard. The burden is on the applicant to prove by clear and convincing evidence that there is a basis for change. And it's not on the opponents to prove anything, although you've got plenty of evidence and will have more. Mr. Remington stated that the justification is the comprehensive plan, which says we need more housing in the village. I would suggest that the comprehensive plan is only part of it. It's not that simple. Rezonings, as Mr. Griffin said, are specific to the parcel. Now, you may remember last year, this commission and the city council revised the R1 and R2 ordinances to increase density. And at that time, it was proposed to put R2 type housing into R1, and the commission turned it down. That did not go into the ordinance. Well, what this is just a way to get around that. Well, then we'll rezone it from R1 to R2. You might as well rezone the whole village if the only basis is that the village-wide needs more housing. You could rezone Cree Meadows, White Mountain, the Upper Canyon, everything if that's it. But it's not. It is land specific. And you've heard from the others about the challenges, so I won't go into that. Mr. Remington said at the last meeting that he wanted to maximize development. This is 1.8 acres. He said that by his calculation, the maximum number of units would be 16. By my calculation, it's 17. By way of comparison, the two development proposals that he has previously presented had a maximum of 6 single-family units in there. Now he's going to 16. Should also point out that if it's zoned R2, those are principal permitted uses. He has an absolute right to put 16 units in. He can get a conditional use in R2 to put quadruplexes in, which would double it. That'd be 34 units, whereas the most that's ever been proposed is 6. I think the last thing I would say in your report from the staff, it says that the staff says there will be no effect on property values. That's absurd. I don't know where that's coming from. The report does not say what it's based on. Anytime you change anything, it's likely to have an effect one way or another on property values. Following up on what Mr. Forsyth said, and incidentally, he's former sheriff in Dallas, there's just no question that this would absolutely destroy our property values. We're immediately adjacent to it at 106, 108 Keys Drive. And as a property owner, I can tell you, it would devastate our property values to have certainly 34 units and 16 units. It has to stay R1, and that's what you're deciding today. What's appropriate? What will it support? R1, for all the reasons you've heard, is what it needs to stay. I thank you.
Thank you, Mr. Rennick. Who else wishes to speak for or against this item? Yes, ma'am. Step forward. State your name and raise your right hand.
My name is Joni Markham. I live at 110 Keys Drive.
Swear to tell the truth.
Swear to tell the truth.
Thank you.
Okay, if I could ask you to go to the map that we have that looks like this. I just want to point out that where Wingfield goes into Keys Drive, that's exactly where I live. And my property butts up to the so-called cul-de-sac. And I wanted to show you a video I believe it was sent to Stephanie earlier, but I have it right here, of what it looks like right behind my house where they want to possibly build. And this is after this was taken, how do I get it to go?
It's not working again.
I'm hitting play.
iPad assistant.
Just run it. This is what it looks like when there's a good rain. What? It's not running?
Oh, you
And
just push something
there-
over the
there-
picture.
I'm sorry?
Hit the X on the ad. X the ad. It's above on the right. It's at the top on the right.
Start it over.
Top on the left? Yeah.
Okay. But this gives you an idea of what happens after a good rain behind my house. And according to his map, he has development over where this is running, pretty much. And on a personal note, one of the reasons that I live there and a lot of the other people that live there is because it's a beautiful, quiet neighborhood. I have a neighbor who is retired from the military, who served for our country, shared with me that he had PTSD, and he needed a place to live where it's quiet. Behind me, I already can hear, because it's coming from the west, children laughing. You can't beat that. But at night, I have to close my window sometimes because the fights in the middle of the night, the vulgarity, the screaming, the hollering. And I would really hate to have to see my neighbor move.
So for clarification, at the Wingfield extension, there's two lots. Are you, which,
Everyone by the cul-de-sac.
okay, got it. Thank you. Who else wishes to speak for Mr. Rennick? Again, the other Rennick. Mr. Rennick, state your name, please,
Sam Rennick,
and you swear to tell the truth, nothing but truth.
I do.
Thank you.
I just want to echo a couple of points that have been made. Those of you in this room who are attorneys know that there's the saying in the legal profession, if your case has bad facts, argue the law. If it's bad law, argue the facts. With all due respect, Mrs. Warren has neither facts nor law to support her position. All she has done is make a statement of opinion. Number 2, staff finds the granting of this rezone would not adversely impact the health, safety, welfare, property values, or neighborhood character. She has nothing in support of this, and in fact, my brother just mentioned property values would be adversely affected. She has presented no evidence in support of her allegation that property values would not be adversely affected. She cites a couple of the clauses in the ordinance, but when it comes to the law, it is Mr. Griffin who has cited the law. And the law is the Miller case. And in that case, the court cited the treatise by McQuillan on municipal corporations. We've already gone through this, but I would just add, and I'm sure this isn't lost on Mr. Cook, ordinarily in a case like this, I would think a preponderance of the evidence would be the evidentiary standard, but it's not. It's clear and convincing evidence. Mr. Remington hasn't even provided us with unclear or unconvincing evidence. He hasn't given us anything at all. He said virtually nothing last time, and today he came in and he said, well, I admit a little ambiguity previously. I'm thinking of 11 units. He showed us the map. That's about all he said today. Thank you.
Thank you. Who else wishes to speak for or against this?
Mr. Chairman, I'd like to clarify density if I could. On the 1.87 acres that we're talking here, the principal permitted use would allow him 16 maximum for single-family detached dwellings or two-family detached dwellings. He would have to apply for a conditional use permit that would allow him no more than the 4 units, should he choose to do townhomes or apartments. That's the way the code reads. Density is less with a conditional use, but that's what we would hold him to, how the code is written.
Thank you.
Mr. Chairman, it's Charles Rennick.
Yes, sir.
If you'll indulge me for a second, what Samantha was referring to, 4 units conditionally, means per lot. Right now, it's 1 lot.
Right.
He would divide it up into multiple lots.
Understood.
It would have to be replatted before we could approve it, wouldn't it?
Yes, Chairman Briley, Commissioner Williams, it would have to go through a replat before we could consider that. But as it is right now, it is 1 tract of land.
Yes, sir.
If you approve this,
Sorry.
if you approve this, and that would put R2 there, then would he be able to get the same zoning all the way up to the top of the mountain? Where he owns it?
Potentially anybody contiguous to the R2 zone would be able to apply for a rezone.
So basically, if they approve this, they have backdoored into 6 acres into Green Meadows with R2 when you said you didn't think that R2 should go into R1.
Before I ask Mr. Remington to come back, is there anybody else that wishes to speak against this right now? Anybody online? Yeah, I'm going against first. Seeing none, Mr. Remington, do you wish to comment or cross-examine anybody that gave testimony against this? Seeing none, I'm going to close the public hearing. Commissioners, thoughts, ideas, questions, answers?
Mr. Chairman,
Yes.
sorry that I'm a little dense. Can we just validate the density? So as it's currently platted, the 1.8 acres, without a conditional use, he would be able to have up to 16 units if they are not townhomes or duplex. Yes or no?
Yes, Commissioner Rigsby, single-family detached dwellings or two-family detached dwellings.
Okay, so if he wanted to have 16 without doing anything else, if this went from R1 to R2, he would be able to do that.
Of those types of dwellings, yes.
And if he wanted to do, if there was anybody that wanted to do duplex, triplex, fourplex, small multifamily, that would require a conditional use.
With a maximum of 4 units.
And in that case, 4 units would be 4 quadplexes, as an example. So it would be potentially 16 living units.
No, 4 dwellings, so 4 dwelling units, not 4 sets of 4.
Okay, so the conditional use has lower density.
It does.
Okay, and what is the density for R1?
1 home per lot, unless you have a
Per lot.
conditional use, then you can add another accessory dwelling unit to have like a mother-in-law type quarters. So you can have 2 per lot in the village.
With a conditional use.
Yes,
And there are 2 plats in question, or are we just discussing the 1.8 acres, that one plat?
correct. We're only talking about the one, the smaller
Lot
tract of
B1.
land. B1.
Thank you. Okay, just clarifying.
Commissioners?
Sam, is there a minimal lot size as far as like R1 would be?
Yes, each zone has a minimum lot size.
100 feet deep, 75 feet wide.
Is there a square footage on that, or is it just simply by measurement,
Just by the measurement.
by the measurements? And is there a restriction as to how big a place you can put on that one lot, or?
Covenants typically describe, no lots can have a home less than 900 square feet or things of that nature. The Village of Ruidoso, we don't enforce covenants, so we do allow tiny homes to be built on single-family lots throughout the community.
Mr. Chairman. Another question for Samantha.
Go ahead.
The adjoining or abutting R2, is that technically in a separate subdivision?
I do not have the subdivisions laid out here, but according to the replat here, it's showing Woodland Ridge as that subdivision.
But the property is in?
Green Meadows.
Right.
This is the map I provided you.
Thank you.
Thank you, Mr. Chair. Next chair. All right, folks, we've heard this twice. We asked everybody to come back with what we asked them to. They did. What's the pleasure of the commission?
Mr. Chairman,
Yes, sir.
I'll make a comment and then I'll do a motion. This is just my comment, my opinion. I don't think it is fair to assume density will have a negative or adverse effect on living conditions. In this village, we need folks living here. There's only so many available lots within this area. So I will make that comment that I don't think it's fair that there will be a negative or an adverse effect, specifically because I've lived in high-density units over the last 10 years. That being said, the motion that I will propose for a couple of reasons, and I'm happy to give those reasons now. One being that the plan in action doesn't adhere, from what I said, it sounds like, to the density requirements, from what Sam was saying. And two, because it's across subdivisions, I don't know if it's the best rezoning, because they are two different subdivisions. So what I will motion is that let me find the wording. Based on the foregoing facts per 54-65 and 54-93 of the Village Code, I move to recommend denial of the rezoning approval recommend denial to the Village Council for the rezoning classification for case RZ 2022-431.
I second.
So we have a motion to deny. So Samantha, I guess the applicant still has the right to appeal to the city council our decision. So this is still a recommendation to the village council, correct?
Correct.
Even if it's a negative.
Yes, they can choose to continue their application with your all's recommendation for denial.
Okay. Discussion on the motion. We have a motion and a second. We need a roll call vote, please.
Commissioner Baugh? Aye. Commissioner Briley?
Aye.
Commissioner Byers?
Nay.
Commissioner McElina?
Nay.
Commissioner Richardson?
Nay.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Aye.
Hold on, I have to do math.
I believe the motion carries.
Doesn't it have to do it by a certain majority? Well, this is just a recommendation, so variances do. Variances, 2/3.
While she's doing that, there is a provision in the clause that if 20% of those that live within 100 feet of this property protest the village council, then every village council member will have to vote in the affirmative to rezone. Otherwise, the motion dies. So. The code reads 100.
So Stephanie, there's no percentage on this one. This is a variance, so it's 4-3. Which direction?
Is it over the 2/3?
No,
4-3?
not on this one.
Then motion carries for
Motion, motion carries to deny. All right, so we are probably going to not, okay. So the commission is recommending the council to deny this application. Glenn, you still have the right to go to council and state your case, as so do all the opponents that get to go and stress their testimony as well. So I was going to say, on the site plan, we will see it again if it does approve, except me. I won't be part of the site plan approval process. So good luck. Thank you, everybody, for your time and your testimonies. And we really appreciate all the people coming in to, I guess, be very concerned about the welfare of the village of Ruidoso. Thank you so much. Next item. Next item is also continuance of a site plan and concept approval, case SP 2023-4. Mr. Cervantes. If you read the minutes and remember last month what we did, we do not think that there was enough information, and there was still a lot of staff comments that were not yet available. And so that is why we have this as a continuance of this site plan and approval case. Samantha, Stephanie, does anybody want to update us on what has been presented?
Thank you. We were able to gain more clarification on the site plan. Additional details were provided. We had a okay from our assistant fire chief on the ingress and egress, as well as Public Works weighed in on their recommendation that they seek approval from the New Mexico DOT, as well as when they go to connect to public utilities.
Is the applicant or agent here for this case?
Good afternoon. This is William Cervantes.
Mr. Cervantes, so I'm going to ask you to raise your right hand and swear to tell the truth, nothing but the truth.
I do.
All right. So tell us what the plan is and what has changed since we heard this last month.
Well, based on an email I received from Stephanie, it sounds like some of these issues have been cleared. The only one is a comment from Mr. Adam Sanchez that says we need to coordinate with the New Mexico Department of Transportation for a permit and then check into the sewer hookup. Looks like our additional information for the site plan was turned in and received. I think that looks like it's okay. And we also got our landscaping plan approved from the forestry. So unless there's something else that I'm not aware of, I think we're close or pretty close to being having everything submitted.
Very good. Samantha, I had one question, and did Adam leave? So there is also another driveway access curb cut near Kirkman, and they are planning to get rid of that and put up curb and gutter and new sidewalk and everything in that location?
Yes, we do not want them to be using that as access for this development.
Very good. And so, Mr. Cervantes, when I was at work yesterday, I did talk to the permit people, and they said they like to hear if there's new, new application for new owners or a new, a new business or whatever is in there. So Shane Olds is his name down there. Just give him a call, and I'm sure that he'll be able to take care of anything that you need to with regarding that existing access. Shouldn't be a problem. Commission, questions? Seeing none. We had a public hearing on this last time as well, but I am going to go ahead and open it again for a public hearing. Does anybody wish to speak for or against this application? Going, gone. Close the public hearing. Commissioners, what's your pleasure?
I'd like to make a motion if
Go ahead.
nobody has any comments.
Nope.
Go ahead. Comment.
Is this is current, right? So if we did that easement or did the vacation right away, would that, have we got an answer as to whether it would adversely affect fire emergency vehicle access?
I think she said that the
Has it been cleared?
the access was cleared by the fire department, correct? Yeah.
Okay.
So there's one on Kirkland and then there's one on Meacham.
Yeah.
So straight through, correct.
Based upon the foregoing findings of fact per 54-67 and 54-100 of the Village Code, I move to grant the site plan and conditional approval for case SP 2023-4 with the conditions stated in the case report.
I'll second.
We have a motion in 2 seconds. Can I get a roll call, please?
Commissioner Bach?
Aye.
Commissioner Briley?
Aye.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Aye.
Motion carries.
Thank you. Mr. Cervantes, proceed. Petition to vacate Green Meadows Drive case PVC 2023-17, Joni Markham. So, Sam, you want to give a briefing before we hear from the applicant?
Yes, this portion of Green Meadows Drive has never been built out. They previously petitioned the village to vacate that. The full procedure wasn't followed, and so therefore the vacation was never recorded or allowed. To our records was never any follow-through from the applicant at that time. So being brought as a new case, and they're going to be able to demonstrate, hopefully, why the vacation would be necessary, as well as we can explain that if it is granted by the village council, then we would have to offer it to everybody that's contiguous to it for purchase.
That's what I assumed, but I did not see that in our, 54-73 doesn't necessarily say which part of ownership goes to such, but it's normally, if it's 50-foot right-of-way, 25 goes to this owner and 25 goes to the other owner, correct?
Yes, we'll follow state statute for
Right.
vacation.
All right. Mr. Griffin, are you here for the applicant? I see your letter. Come on in and swear to tell more truths. Swear to tell the truth? Good. Thank you, Mr. Griffin.
My wife told me I spoke a little fast last time I presented to you, so I'm going to take advantage of maybe a little breath in between if I can. As I mentioned earlier as well, it's important to note that the particular tract that is in dispute, if you will, tract B, is one that has not been developed since 1961, despite the fact that it was actually platted in 1961. If you go out there, as I asked you to do, and please do, you'll note that the survey markers are for what Green Meadows Drive might be. But you'll also see that the slope of that ravine makes it kind of difficult, even for the construction of that road. We can all sit there and say, I see where the stakes are, there can be a road here. But inevitably, accretion and avulsion from two adjacent properties could be and should be an issue there, whether it would be dirt flowing down from my client, Ms. Markham's property onto the cul-de-sac, or construction from the cul-de-sac undermining my neighbor's property. So there's a reason, I suppose, from my client's perspective, as to why it was never built. An amended plat called the Green Meadows Edition was filed of record in the office of Lincoln County Clerk in August 31, 1961 by its original owners, the Swearingen, did I say that right? Okay. And in the ensuing 63 years, it's never been constructed. Also, I'll remind you that the subsequent owner, or one of the subsequent owners, sought to vacate Green Meadows Drive in 2009, going so far as, and if you will, refer to the record, the file that I have given to you contains your, I say you, this group, but not the same individuals, discussed this very issue. And there, it seemed to be a consensus, if you look at that record, that it wasn't going to be developed. The surveyor said it, the planning commission said it, and it was even said to the village council, and the village council voted in favor of vacating the street, saying that it would never be, the entire tract would never be developed. There was also a concern in the planning and zoning meeting that perhaps that property was being still taxed to its original owner, the Swearingens, and later the Petersons, as their individual property that had not been accepted by the village. The question was addressed then, well, we'll vacate it. I believe that was the answer to the question, who's being taxed for that property? We're going to vacate it. But I have not checked, and I don't know if anyone here has, whether the assessor continues to this day to assess the property that constitutes Green Meadows Drive as real property to the owner. I suppose Mr. Remington could tell us about that. I wanted to mention to you, too, that the authority to vacate platted streets and these considerations are part, again, of municipal law, Statute 3/2012, that says any plat may be vacated, or the portion of the plat may be vacated, provided, one, the owners of the land and the territory proposed to be vacated sign a statement, and we have, Joni Markham signed the statement, but we have many in support of that vacate. And I think we have 10, I believe it was 10 letters that were sent in support of the vacate. So that's one. We got 1 out of 2 from the state requirement. The second one is the statement is endorsed, approved by the planning authority of the municipality whose platting jurisdiction the subdivision lies, and that gets filed with the county. Well, that never happened. In 2010, after the vote, as Ms. Cerna pointed out to you, the village failed in its obligation, I suppose, or in its function, mere administrative function, to take the paperwork to the county. But since 2010, when that vote was made, I will argue, here and wherever else I need to, I suppose, that my clients have acted in reliance upon that vacate. And again, a reliance action is one that the party who makes a statement doesn't necessarily guarantee, but they run the risk that someone could act in reliance upon that. My client has represented to me that she has actually tended the earth, that she's mowed and watered in portions of what now constitutes Green Meadows Drive. I know that we can't adversely possess against a municipality, and I told them that. But still, the concept exists as to why would you vacate? What is the public interest? Those are some of the points that we need to raise. The considerations, I'll just go ahead and tell you what they are from the state statute. In approving the vacation or partial vacation of a plat, the planning authority of the municipality shall consider if the vacation or partial vacation of the plat will adversely affect the interests or rights of persons in contiguous territory. I like that, because it seems like we spend a lot of time talking about the owner of Tract B. He's only one of the people who surround the potentially vacated street. And that's Section B of New Mexico Statute 3/2012. The Ruidoso ordinance also addresses this, and it says that a vacation may be approved if it is determined that, and there are 3 criteria. It's interesting, though, 1, 2, 3. One is there is no convincing evidence that any substantial property right is being abridged against the owner, the will of the owner of that right. Again, I put to you that everybody who's contiguous to Green Meadows Drive is actually we have 5 individuals. I think I have those listed here. The Markham Family Trust, Chris Sanchez, Ron Buckner, Trace Hermanos LLC, and Mr. Remington. So those are 5 owners with interest, not just one whose interest in maintaining or vacating the street. So the first one is there any convincing evidence that substantial property right is being abridged? What is the substantial property right? We should probably identify it first. Can he get to his property? Absolutely. So that's not necessarily the substantial property right. And he doesn't own Green Meadows Drive. It belongs to you guys. So it's not his property right to use that road necessarily. So a vacate, you'd have to say, does the vacate take away his right to access the property? And I offer to you that it doesn't. From the west, there are 3 dead-end streets that abut Tract B. And from the east, he has the short section of Green Meadows Drive that we never have attempted to vacate because it does appear to be an entrance onto Tract B. So to enter Tract B and then turn right and travel some, I think it's 150 feet or so, is not a substantial right of the property owner of Tract B. But then it says and. So you have to have that criteria, no convincing evidence that anybody's rights will be abridged, and that the public welfare is not served by retaining the way. So we'd have to say, is the public welfare being served by it now? And unfortunately, this particular ordinance gives us an or. So it's not real clear, but it seems clear to me that it's an or between 2 and 3, not 1 and 2 together or 3. It's 1 and either 2 or 3. So let's talk about what 3 says. 3 is the development made possible by the vacation results in a net benefit to the public welfare, which is clearly more beneficial to the public welfare than the minor detriment resulting from the vacation, which is what I'm hoping that you will see in this instance. There's no real convincing evidence that a property right of anyone would be abridged by the vacate. And I would say that it would be incumbent upon us, of course, to state that there is no right being abridged. But I offer that statement has got about as much weight as a lot of the other statements we say there's no impact on health, safety, and welfare. Well, prove it. How can I prove the negative in this instance? That's going to be a little bit difficult.
That must have been your time alarm.
Hey, what? Sorry. She knows how to do it too. Okay, so I'll try to be a little more clear. We talked, and I think that the commission has already mentioned its awareness that the proportional interests of the vacated street would be doled out, if you will, provided that the adjacent properties pay. I would just want to mention then, substantial property rights, what are they? If we look at the fact that that property hasn't developed since 1961, and there's a reason why it has not been developed since 1961, then I would say it's not whether or not Green Meadows Drive exists. I would say that's not going to keep the property from developing. So I would say, again, if I anticipate the negative, I don't think that we have an abridgment of Mr. Remington's rights if we vacate the same street that his predecessor asked you and the council to vacate. But I did mention reliance expectancy of the other 4 owners to have gone 12 years believing that the street had been vacated. We have those 10 statements from people in surrounding areas, but I can't confidently tell you that they're within 100 feet, as you mentioned. I don't think we have that number. I don't think we can compose that for you today. But we seek the vacation of Green Meadows Drive, and it's largely because we anticipate that it would be an invitation for greater traffic to hit Green Meadows. Again, the whole reason why we're here, and the whole reason why we've opposed Mr. Remington, I think he thinks that we don't like him. It's we don't like the ideas that have been brought before you. The idea that there would be much more traffic, and we fear that there would be a lot more traffic in Green Meadows now. I just wanted to mention, as far as the public welfare is concerned, it may be hard to define what public welfare is, but let's think about it in terms of such expectations as privacy, peaceful enjoyment, security, health, and maybe wander into those words, health, safety, and welfare if we can. Those are the kinds of things that we have to take consideration of. But it's not about one person, it's about many. I'd also mention it, good to see my last page. I'm sure you're happy to see it too. Village of Ruidoso makes no current use of the current disputed area, but we speculate. Unfortunately, I do it too, and I think are all guilty of it. We speculate how Green Meadows Drive could be used. But that's not necessarily our task here today. We're asking that the village complete the process that was begun in 2009, 2010, and follow through on the idea that it's not being used and that it doesn't have a use. On the other hand, we and you and Mr. Remington can't specifically state what use it would have. It was designed to be access to all the properties around it, I'm certain. Anytime anybody does a plat like that, they don't prevent these properties from using a cul-de-sac. It was designed for the access of all those properties. The other 4 properties don't care about it now. There's only one owner who would care about using that access. Now, there may be an issue as well. We talked about this briefly. I'll just tell you that the 40-foot radius will not accommodate fire trucks. So it's designed from a 1961 drawing, and it still remains as a 1961 drawing with a 40-foot radius at the cul-de-sac. I can offer it to you, and I probably should because Joni provided it for us. Fire apparatus access, it's the International Fire Code 2021 version that shows that a 96-foot diameter or 48-foot radius is the minimum required for a cul-de-sac, and this is 40-foot radius. Not that that's our biggest reason. The obvious solution might say, oh, let's make the cul-de-sac bigger if we're going to use it. But then I would ask you to just ask yourselves, has anyone said that there is a use for it? Is there public welfare at stake right now if we don't develop it? And I think the question could be answered with a no. May I share this with you? Sure. I'll stand for questions.
Pass it down to Stephanie. Thank you.
Thank you.
As I stated in the first part, this is quasi-judicial, and everybody has the right to cross-examine everybody else. So, who else wishes to speak for or against this? Come forward, state your name.
Terry Forsyth, tell the truth.
Thank you. What was that, Stephanie? I thought I did before. Sorry. I meant to open the public hearing before Mr. Griffin. So I officially open the public hearing now. That means Mr. Griffin's going to have to say all that all over again.
He was on behalf of the applicant.
He was given the presentation on behalf of the applicant. Okay, so we are now under public hearing. Anybody wish to speak for or against this? Yes, sir. How do you wish to talk about this?
I've been surrounded by lawyers, for years. I'm not going to get into all of that. I just always try to see what's fair. I don't think it's proper for the village to have tried to sell that road, Green Meadows Drive, to Mr. Remington, and he refused to buy it, and none of the other people that were contagious to that property were offered the same thing. This lady wants to buy the property. She wants to exercise her right the same way that it was proposed to Mr. Remington before I found out that y'all had vacated the road. Any questions?
Thank you. Okay, I see all kinds of hands go up. I saw over here first, so I'm going to go back next to Mrs. Remington.
My name is Justin Remington.
Justin, come on up to the microphone.
Well, I just spoke with-
Justin, do you swear to tell the truth and nothing but the truth?
I do.
Thank you.
I just want to comment on what was just said. My father was never given the opportunity or the, they never offered to sell it to him. So I don't know where that information is coming from.
Okay, thank you. And I'm sorry, I'm having trouble with names.
Scoutmaster works.
Okay, swear to tell the truth, but nothing but the truth.
Yes.
Thank you.
So when we bought the property at 202 Keys, it was a vacant lot in 1999. We met the property owner behind us, Burl and Beverly Peterson, within about a year of us putting the house in, and they discussed the restrictive covenants that came with the property. That was really cool. He also discussed the possibility of us helping take care of the property behind us to create a buffer zone for fire behind us because he knew he couldn't afford to take care of it for everybody. So we had a gentleman's agreement, as it were, on a handshake, that we were allowed to help clean the forest behind us, keep the grass down, rake. If trees needed to be cut down, we went to him with all of it. In 2000, whatever, somewhere around in there, he tried to have it approved to put, was it 11 houses? 11 houses in the entire 6+ acres. Planning and zoning came forward at that time and said, under no circumstances does the north end, which is what we discussed earlier, look like it can be developed. He allowed for no more than 6, I think, on the south end, up down off of Woodland, up that direction. Peterson decided at that point in time he didn't want to get involved with the north end, so he directly petitioned the planning and zoning to vacate the property, the right-of-way, so that the property owners in the houses in front of him could take care of their own space, and he could take care of his. We all did our due diligence. We're not lawyers. None of us are legal trained members, and none of us have sat on the committee, and I will tell you this, God bless you for doing it, because how you can sit there and make decisions and know that the next committee can throw it out boggles my mind, okay? The point is, the village of Ruidoso didn't follow through with what they said they were going to do. And now the property owners in the area are being penalized for it because the judge said, well, the village didn't follow through, so you got to start all over again. So they're putting the onus back on the direct people that live there, that this is our livelihood, this is our homes, this is why we bought where we are. I'm not denying the fact that, yes, there's the possible use for this acreage behind them. However, the vacation of right-of-way serves only to ensure the fact that this end does not see more traffic incidents with children in the neighborhood. And in the winter, as a matter of fact, for the last 20+ years, we've been pulling cars out of the ditch at Wingfield and Keys Drive because they come too fast and that road has a high tree and it doesn't melt. And so they've already had to put the stop sign up once this year, because somebody slid right through it. If you follow Wingfield through, it goes right into Joni's garage. You have to stop, make a full, complete left turn, go to the other side of Kay's house, what is now Chris Sanchez's house, where that vacation would start is that little piece of property in between Ron at 200 and Chris Sanchez is at what, Chris? What is it? 104. 112. I don't have the numbers because it was Kay's house for 20 years. For 20 years, the village of Ruidoso, the street department, forestry department, and everybody else have ignored this piece of property that we're asking for the vacation of. For 20 years, Ron Buckner and I helped take care of Kay, and we cut dead trees down, and we moved trees out of the way because the village said, it's not our ball of wax. It doesn't belong to us. But then suddenly it did belong to them. So now all we're asking you to do is help make a decision and let us know, are you willing to just give it to the people around it that have been taking care of it for 20+ years? And I have nothing to gain from this, okay? I have nothing to gain from this. I'm just asking you to please follow through with what your predecessor said and go with God in all of this, because I don't know how you guys do it.
Some of us are going to retire from this.
Yeah, and you'll come back in a decade.
Anybody else wishes to speak for or against this item?
I do need to rebut that.
Okay.
Director Mendez, at some point in time, did you not offer to sell Mr. Remington Green Meadows Drive for $30-something thousand?
I think it did come up during one of our public hearings when he was proposing developments that if he did want to incorporate that portion into the development, that he would need to pay for it, and it didn't belong to him.
I'm not in the habit of lying to a committee.
Thank you. Mr. Remington.
Can I make one statement, though, that I'm not sure if the applicant is aware? Should this be vacated, you're just decreasing the amount of space between your property and the potential development, the setbacks will be reduced?
I'm not sure what that exactly means, but are you saying that, in other words?
The lot lines will be adjusted, so it's potentially closer
Well, if
to.
they move it any more west, it's a ditch, so.
Yeah,
Yes.
because it's sort of like a buffer now, but.
It's a split
But then they would have to move the road.
if they put a road.
You would have to move
Right. Mr. Remington, you swear to tell the truth, nothing but truth. Please.
First thing I need to clear up, Burl Peterson, God rest his soul, he does not own that property anymore. My wife and I do. And any old plat map that I ever saw, very plainly, on this 6 acres, said future development. Now, they wouldn't have put Green Meadows Drive in there if they didn't expect it to be developed. Now, we heard someone say that that road couldn't be built. Well, this is a pretty accurate representation of it, right here. And it looks pretty easy to build from where I'm sitting. I mean, you got Grant Street over there to the west, that's pretty steep there. You know, this is the mountain. You got to expect those things. I'm an eternal optimist. I hope that in the future, we will get to develop our property in one way or another. And that would be a good access. Green Meadows Drive would be a good access for any future development. Now, I'm probably, if you total up all the length around that Green Meadows Drive, I'm probably the majority property owner. And I'm just opposed to it. So, thank you very much.
Thank you, Glenn. Anybody else wish to speak for or against this? Yes, ma'am. State your name, please.
My name is Bonnie Coe,
Please.
and I swear to tell the truth.
Thank you, Bonnie.
Anecdotally, speaking about that lot, I knew Kay Yateman for over 40 years. And I used to go visit with her, and she would always tell me, now, let me digress a little bit. Dana talked about Wingfield coming into Keys Drive and then going across this lot you're talking about. It's a dogleg, it really is, and it's on a slope. And Kay Yateman used to tell me, she was disabled, couldn't move a whole lot, but her winter entertainment was to look out that front window and watch the cars slide down the hill and into ditches and whatever. So that really does make it very precarious as a traffic pattern there. Mr. Remington said, Mr. Remington owns that wash down there, and if you look at the plat, he still has access from the west from 4 streets. There's Apache Hills, I think there's Zia, Verde, and something else. It's not that it is going to put a stranglehold on his development of that land. He's going to have more access as well as 2 exits for fire, because you can go down and pick up 5th Street and evacuate, or you can go over toward Grindstone Lake. I just wanted you to know that that dogleg sloped access is very detrimental. Also, Mr. Sanchez is my son. He owns Kay's house now. And if you look at where the stakes are, that they when he purchased the house and where the stakes are, that lot is, to develop a road there puts it like within 15 to 20 feet of his south wall. And so when you look at developing, and I'm not a road developer, but it isn't just the pavement. You have also all of the gravel on the sides and the drainage and whatever. And so it puts all of that very, very close to his house as well as to Mr. Buckner's house. Thank you.
Thank you, Bonnie. Anybody else? Yes, ma'am. And you got to state your name again.
Joni Markham, I promise I will tell the truth.
Thank you.
Just to add to the last comment is, if you look at your maps, all the homes west of his project will have access. All those homes will have access to the roads coming to Keys Drive, where there is already a It's a dangerous amount of traffic to begin with. So not just the project that he's working on will have access to that, but all those other homes. Keep that in mind.
Thank you. Anybody else wish to speak for or against this? You may. Let's play nice.
Mr. Chairman, before they get started, can I clarify on a comment that was brought up, that the village failed to file, the plat, the village doesn't file plats, the burden's on the applicant, so the applicant would have had to have remitted payment and filed the plat with the county clerk. And then as far as building out Green Meadows, that has to come from the private property owners, and then we would maintain it and accept it into our public, maintained road mileage. That's all.
Was Ms. Markham the original 2010 applicant for the vacation?
I don't have that application.
Peterson, thank you. Thank you.
Thank you. I hope
Go ahead.
you can hear me. Sure. Mr. Remington, are you aware of how much acreage is in the area that comprises the part of Green Meadows Drive that we want to vacate?
No.
Would it seem accurate to you? I measured it with my own calculations, about 4/10 of an acre.
Sounds reasonable.
And do you know that we're not seeking to vacate the, I guess it's the extension of Wingfield, is that what it is, where it comes just up to?
Yeah, and I that's fine. I don't understand it, but whatever.
Well, I'm hoping that you might understand. Did you understand that if we vacate it, you get half of what's left of Green Meadows Drive?
I do.
Or roughly half, I think, this proportional value. So you'd be adding maybe even as much as a quarter acre to your overall acreage. Are you saying, though, that you need Green Meadows Drive to have access to Tract B?
No. But it is access on that side of the drainage, so maybe that's one reason they created Green Meadows Drive, to have access to development on that side of that drainage.
Couldn't you just, though, once you get to Tract B, couldn't you have it be internal auto course instead of a
Well,
dedicated?
you'd have to deal with the drainage. I mean, the way this is designed here, I'm staying away from the drainage. We're not building anything over drainage. There's no roadways or anything over the drainage.
Wouldn't you agree then that if you had an extra quarter acre up the hill, that would be helpful to your development?
No. The Green Meadows Drive is much better for me than having that land.
But I think you stated you didn't absolutely need it for access to Tract B, correct?
I mean, without building something across that drainage, that'd be the only way. Right now, Green Meadows Drive gives me access to that side of the property without going across drainage.
Why do you have to have it be a dedicated street? Why couldn't it be part of your internal auto course?
I don't know. I mean, if I can get the village to take it and maintain it, that's great.
I understand. Thank you. Thank you, Mr.
Anybody else want to drill Mr. Remington? Mr. Griffin, thank you for your cross-examination. Go ahead.
I do want to clear one thing up about this 2010 request for vacation. It did go through all the way to a court, and a judge decided that it was gone, couldn't be done. Is that right?
Are you assuming the village and the property owner at the time did not go through the process because of the judge?
All I'm trying to establish is that issue was put to bed. I mean, if they're trying to bring something like that up, well, they can't. Am I correct in that assumption? The judge has ruled.
We haven't seen any paperwork, so Glenn, I really can't answer in either
Does
kind
anyone
of
in
commission.
here know the answer to that?
We lost it in court.
Okay, well, there you go.
The statute of limitations got us.
Thank you.
I have a question for the applicant. Why are we not vacating the portion in between those two lots there? Just on the backside.
Wingfield extended?
Well, it would be nice, but we didn't want to go for too much. I mean, we're start it, just start it what's behind our house.
And to afford access to track B.
Well, I think they dedicated different times too.
Samantha, they did not speak on the microphone. Did you hear the answer?
Can we get somebody to go to the microphone? I'm sorry, it's being recorded. If we can get an answer of why the application doesn't include that.
We got a lot of good minds on this issue. Larry Forsythe is one of them. And he's back there telling us that it was part of a different dedicated, and I like that approach. I like that approach for the simple fact that if it had a different purpose. And allegedly, that was the second addition to the Green Meadows addition that, or no, it was the first addition that had that extension of Wingfield. But the other reason, and this is what I understood, I asked this very same question. I said, why aren't we going for the whole, all the marbles? And it's because there's also a necessity for access to Track B from that side. That's the presumption of the neighborhood, is that that's why it was put there. But then the piece that goes off to the right doesn't have that same necessity. And I think as Mr. Remington and all of us have tried to point out, this is a serious ravine. So where Green Meadows Drive is on the east side of that ravine. But I was just offering to Mr. Remington that it could be part of his internal auto course and doesn't have to be a dedicated street if he's looking for access through there. But I hope I answered the question.
I think Samantha got the answer. It's, at least I understood it. Okay, we're still in public hearing. Is there anybody else to speak for or against this topic? Hearing none, I'm going to close the public hearing. So, Commission.
Mr. Chairman, I've got a question for our attorney, Mr. Cook.
You have to raise your hand first.
I heard the beginning of some fruitful conversation between Mr. Remington and the attorney. I think Mr. Remington was offered some suggestions that he didn't really have time to consider, that maybe there's a possible good outcome for everyone here. Is that something that we can take into consideration, to table possibly, and let them have more conversation and bring it back?
Yeah, you could. You may want to ask what the opponent's position is on that request.
Mr. Remington, is that something that you would consider?
I mean, I don't think half of that right of way. Should I come down here?
Please.
I don't think half of that right of way, the half that we would get would be enough to do anything with. I mean, right now, I was schooled on this when I was doing the last thing. There's a difference between village property and a right-of-way. It's a public right-of-way. That means everyone, the public has a right to use it. It's not, it's a little more difficult to dispose of for the village. So I'm totally against the vacation.
Thank you, sir.
I don't think anything could be worked out.
Thank you.
Commissioners?
Yes, if we keep this bit of road that the village is responsible for, what are we responsible for regarding it? Are we mandated to maintain it? Are we mandated to at some point make it drivable, et cetera?
No, we're not mandated to build out Green Meadows Drive. What happens is the private property owners in that subdivision build it out and maintain it for X amount of years, and then petition for the village to accept it into our road mileage log. And then at that point, we would maintain it. It has to be built up to village standards. We would be required to maintain it to the forestry standards, though, just like they do all of the other lots and areas in the village.
Mr. Chairman,
Yes, sir.
I heard Mr. Griffin talk about this, and then Ms. Cole backed it up, and then Ms. Markham backed it up as well, saying that to keep this would mean more traffic on Keys. And it'd be better just to push it off on Apache Hills, Timberwolf, Lay, and Verde. Is that fair? Do y'all think that's fair, just to shove it off on your neighbors? You think it's fair? Okay, just asking.
Commissioners, if not, I'll ask a couple questions. So, with the vacation of public right-of-way, the adjacent properties get 50/50. How does the cul-de-sac work? Does that mean left and right, or does it also include the properties that are to the north along that cul-de-sac?
I think we're gonna have to offer it to all of the properties that are contiguous, and as Mr. Remington stated, it does not sound like he would have much of an interest in purchasing this drive, so we would have to work with them individually and see what their interest would be in acquiring additional land and purchasing it.
So with and from what I remember, a vacation of right-of-way would come with a replat as well, that divides and adds to adjacent properties that land. So we're not at that point right now, right? We're just kind of talking in concept, or is this really a real vacation?
This is a true vacation, and should it pass through council, we will have to work with the property owners that have an interest in it and make sure they understand they're going to bear the cost of an appraisal as well as the replat cost and the filing cost with the county clerk. That isn't any cost that will be bared by the village
And
or
appraised
public
value
taxpayers.
purchase, correct?
Correct. Mm-hmm. If it's over the $2,500.
So to the applicant, I guess my question is, do you realize, I guess, that it's just part, or was your intent to take that whole thing on and purchase and everything? Okay.
I can clarify your first question. The cul-de-sac was
Sir?
divided.
Yeah, we haven't heard your name yet. No, I'm not opening a public hearing. This is just a quick comment.
110 Keys Drive.
Thank you.
I'll tell the truth.
Okay.
I can bring clarity to your question about how that cul-de-sac would be divided, be east and west, not north and south, because Apache Hills subdivision borders Joni's property. So it's in a different subdivision. So it'd just be Joni and Mr. Remington on the cul-de-sac. Because you asked which way that cul-de-sac would be divided, so that's all I wanted to add.
I understand that. I'm not exactly certain if that's right, but it is within this subdivision versus another subdivision, so you could be right.
Right, I'm just saying that.
Yeah. Okay.
The north side is a different subdivision.
And that's why I was asking Samantha if this is the final decision, final plat, final replat of everything, and it sounds like it's not, because there's still a lot of work to do. So what we're doing, I guess, is
If I may interrupt, Mr. Chairman, I'm going to disagree with one of my clients and say that I agree with necessarily the way that the ordinance is written and the way that the New Mexico statute is written. It's a division with all adjacent property owners, and it doesn't distinguish if you're in a different subdivision.
yeah.
Mr. Chairman. That's me. Question.
Oh, yes, sir. Voices from above. Please join us.
I'm here, don't worry. The property on the north of that subdivision, is there any access outside of Green Meadows Drive to that property? If you look at the cul-de-sac, the very north part of it, it looks like there's no access.
I don't I don't see it, but there's a little square there that I can't even read, and I don't know if that's an easement or what, but there is something that's right on the tip of that cul-de-sac. Is there easement?
Mr.
It's just
Chairman?
easements?
There
Mr.
are
Chairman?
other properties, that do have access. Those are properties that face off of Fifth Street, so that's their rear property
Right.
lines.
Mr. Reddick, I'm assuming you're waving your hand because that's your property.
Exactly. It's in Navajo subdivision. The 3 lots that you see there, well, 2 of them are right on the cul-de-sac. All 3 of those have access from Keys Drive.
Right.
The 4th lot in, which is Jody Keys, has access from Fifth Street. So none of these lots to the north rely on that or need it for access.
Thank you. So I guess I'm going to go out on a limb here. Samantha, you and staff recommends denial of this, even though previous councils, planning and zoning commissions have done this. Can you give us a reason? I've read your recommendations, and I guess I'm not exactly sure why. I go back to the ordinances and law, but why by law we cannot do this?
I think you all do have the ability to vacate the land, but I think that it would cause an undue hardship with removing that access and the public land the way that it is platted. I would have rather have seen the entire Green Meadows vacated as opposed to just that strip. But you all do have the liberty to vacate just that portion if you'd like to approve the applicant's request.
Thank you. Commission? Okay, I'm going to ask one more question. So who's paying taxes on this?
I just wanted to ask her, where is the hardship?
From access, as it relates to public utilities, and also just gaining access to that backside of the newly subdivided. We have to understand potential development
Future.
in which that's what we're allowing this, looking at future development, because as you can see, Mr. Remington is very eager to develop his property.
So who is being taxed for this property? Is it the village or is it a proper property owner? Do we know? Can we give and sell property that's not ours?
I'd like to
It is
comment or two. I find it a bit disconcerting that this is coming up while Mr. Remington is in the process of trying to gain approval for developing. It seems like it is something that is being thrown out there to restrict his ability to develop. And at this point, I would rather Mr. Remington find an amenable means of developing his property, and we go forward from that to determine whether it needs to be vacated or not.
Thank you, Bart. Commissioners?
Mr. Chairman?
Yes, sir.
Just kind of following up on that comment, I think that's a really good point, Bart. And second question that I have is, should this vacation go through and Mr. Remington does not want to participate in the purchasing of the property, just so I'm completely clear, the applicant, the individual applicant right now would have to purchase the entire tract, or those that are interested, correct?
That is correct. Those that are contiguous to the vacation would be afforded the opportunity to purchase their share.
Thank you.
I need to ask him.
Go ahead.
I certainly can understand the concern, the way it looks, but what happened is we took that to court when we found out that the village had approved that, and the judge said it was, the statute of limitations had run. And I think that, he said, Mr. Cook, all we need to do was reapply again. So that's what she did, is reapply. And there was no effort to block this. We didn't even know this was coming. She had started her process of getting the utilities and everything else to sign off on it. Only then did we find out that he had a project. So we did not, or she did not do that to try to block this.
That was like last summer, when you had the law case. When did you go in front of the judge? It was last summer.
No, we're not in public hearing. We're just hearing comments. Because I'm waiting for a motion or commission to make a decision what they want to do. Because I want to take a break.
If we did not act on this at this time, Mr. Remington decided to go before the council appeal, then could it be brought back as a possible, as a discussion after that time frame? All parties might feel differently.
Let me ask Stephanie. Stephanie, do you know off the top of your head, or do you have it in front of you, what the ordinance says about continuing these types of cases, vacation cases?
I'd rather we didn't.
I do not, but I can get online.
Vicki, I don't know if that was an answer, but it sounded like a no answer, so does
I'm
that?
looking up the answer.
Okay.
Yeah, Mr. Chairman.
Yes, sir.
The comment I'll make, it says we have three options, right? Recommendation of approval, required modifications of the vacation, or the recommendation of denial.
Correct.
So I think that those three would tell me that we need to make a motion and act upon this in this session, based off of those three things.
Okay.
Okay. So does that mean there's a motion
It
pending?
does state that the application has to be heard at a regular item on the next planning commission's meeting, which would be this one,
And it also says the planning commission shall hear the case and vote.
Yeah.
and not defer.
No deference.
Some,
Oh, my God.
Mr. Chairman, make a motion, please, sir.
Yes, sir.
Based upon the foregoing findings of fact 54-73 and 54-285 of the village code, I move to recommend to the village council to deny the request to vacate Green Meadows Drive for case PBC 2023-17 with the conditions stating in the case report.
Second.
We have a motion and a second.
What?
Doesn't matter.
Three of them.
Give it to Rick.
That's fine.
All right, folks, we have a motion to deny this request and send it forward to the council. Everybody understand that? Roll call, please.
Commissioner Baugh,
Aye.
Commissioner Briley,
No. No.
Commissioner Byers,
Aye.
Commissioner Michelina,
Aye.
Commissioner Richardson,
Aye.
Commissioner Rigsby,
Aye.
Commissioner Williams.
Aye.
Motion carries to recommend denial.
I don't have to give them an answer to my negative vote, do I? Only on variances? We're going to take a 5-minute break, folks. Sorry to keep you here longer, but everybody needs a health break. 5 minutes at 3:52, please.
Take a vacation.
we're going to deny your vacation.
You better not.
It's like negative motion.
Ask her.
Two negative motions in one meeting.
That was a coincidence.
Yeah, don't.
I wasn't even here.
We're all set.
Really?
It's 3:52.
It is. Man, 5 minutes flew by.
Man, 5 minutes goes fast, doesn't it?
Sam, do you deliver to Utah for the water?
Is that where you're at? Are you snowed in up there? Or are you in the flatlands? Okay. Are you ready? Okay, we're back in session. We're on variance request case number PV 2023-25. Taylor Riggs is requesting encroachment. Samantha, you want to give a summary of this, please?
Yes, thank you. This applicant is requesting to encroach 5 feet into the front yard setback at 124 King Richard Drive, Lot 21, Block 14 of the Black Forest Subdivision Unit 2. This property is very, well, I wouldn't say unique for Ruidoso, but provides an opportunity to encroach because of the steep slope at the front of his property. I believe he is here with us today, so I'll let him speak on his case a little bit more.
Mr. Riggs, are you here? Come on up. Give us a summary of what you want to do, and then we'll swear you in and have public hearings and such. Okay, all right.
My name's Stephen Riggs, and all we're trying to do is pretty much get 5 feet farther to the left of the property, is that right?
What's counted as the front, the roadside.
Yeah, roadside, yeah. Just from the building plans, I believe, shown on there.
So it's downhill.
Is it I don't think it's actually going down.
Yeah, so if you look,
Look at the contour.
page 5 is a good
Right.
image that staff took, looking from the road. And you can see there's kind of a drop off on that side. The property line is approximately maybe halfway up that little drop off, maybe closer to the bottom. So we're asking to get a little closer to that drop off than the setback currently allows.
Okay. All right, I'm going to open the public hearing. Anybody wish to speak for or against this topic, please? Seeing none, I'm going to close the public hearing. Commission, what's your thoughts? What's your questions? My only question is, why can't it go 5 feet more to the back toward the lot?
Yeah.
Currently, it's on the back setback. So we
It's
can't-
on the back set.
Yes, it's touching.
Electrical lines too.
So you'd have to build a smaller house to be within
So the plat shows 21 feet to
You're
the
right.
back.
We could move 1 foot further back.
We're splitting hairs here.
That's what engineers do, sorry.
Yeah, well, sorry, when I was drawing this, I left a buffer to allow for, safety factor.
All right, Commission, what's your thoughts?
Mr. Chairman, a question.
Yes.
It would be the front of that building, just to be clear, right? Or is it the covered deck that would go into the encroachment?
So the way, because of the slope of the lot, what we intend to do is build a driveway from the northeast corner, which is the lowest part of the lot, and come diagonally kind of to the west, directly across the lot to the garage. So the part that will be encroaching will actually be the right-hand side, not the side with the garage on it.
Okay. And so that right-hand side, when I'm looking at this, there's a covered deck. Is the covered deck that's in the?
No, that's, part of it is the covered deck, but most of it is the side of the house.
Okay.
Yeah, it's the garage side here.
Go ahead.
This always has kind of interested me. You bought the piece of property, you asked someone to architecturally draw out your home or give you plans for that home, and yet you knew it wouldn't fit on the lot properly. Why would you pick that home?
This is actually the second one I've gone through for a plan. Originally, when I picked it, I didn't really think that it was too big for the lot. I just thought a quarter acre, I was like, oh, it's 2,100 or what was the size of that?
Quarter acre.
I'm not sure.
Yeah, I just figured it was kind of a basic home. I just didn't do my, background on it as much. But I was like 5 feet, was kind of hoping to get some approval for that.
Another consideration is that we weren't aware of the size of the lot until we had a survey done recently. Because this is in Black Forest, we know that some of the technology available to the surveyors at the time mean there are considerable discrepancies between what's on paper and what's in the field. So
Everybody snickers, they all know this, yeah.
So we did work with the original plat record, and we did design a house to fit that. And unfortunately, it's difficult to make it narrower because of wall bracing codes and things like that, which require a certain amount of wall spacing. So the only way to make it narrower at this point is to change it from a two-car garage to a single-car garage.
So you mentioned north-south. North is up on this drawing?
That's right.
Okay, thank you. Commission, thoughts?
So my understanding is that you're not planning on lowering the whole lot, is just sloping the drive to get up there, and that slope on the, coming down to the street will still be there, and,
Yeah, that's accurate.
and
Yes, sir.
it's pretty typical of the area.
So I always talk about hardship. So the hardship is the topography of this lot, correct? Or should I ask now? Correct? Commission, your turn.
Motion.
Yes, go ahead.
Mr. Chairman, based on the foregoing finding of facts per 54-92 and 54-66 of the Village Code, I move to grant the request variance for case PV 2023-25 with the conditions stated in the case report.
Second.
We have a motion and 2 seconds again. Can I get a roll call, please?
Commissioner Bach?
Aye.
Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Nay.
Motion carries.
You didn't have to do the math on that one. Okay. 6E, variance request case PV 2023-29, David Lanning. Sam, you want to give a
Yes.
update on this, please?
So this property would like to encroach into the side yard setback, 7.08 feet. They are located at 133 Singing Pines Road, Lot 47, Block D of the Singing Pines subdivision. This is back in Upper Canyon. This side yard, the next lot over, has a driveway there that there isn't another structure near that side setback, but we have the property owner here with us.
Mr. Lanning,
Yes,
please have a seat. Identify yourself and swear to tell the truth and nothing
David
but the
Lanning, I'll
truth.
tell you the truth as best I know it.
Good enough. So we see you're adding on, and so you're removing some, but you're adding back, correct?
There's already, let me just say a couple of things. When the house was built back in the 30s, they built it at an angle. They didn't build it parallel with the property lines. And so then when they added on in the early 80s, before we bought it, it extended into the setback. I don't know what the setback was in the early 80s, but anyway, it got worse when they added on. And so now we just want to take part of the deck and convert the open deck into a kitchen addition. So it's not going to violate any more than it currently violates. It's just going to be a violation of house instead of deck.
Okay, so from this drawing, where it says addition, that is something
That
that's
is a
already
deck
been
right
done?
now. There's a
Okay.
picture on there too where
Yeah, we've
you
got
see a
pictures.
picture of the deck. And we're just going to tear the whole deck out build the addition where the deck is currently and then build new deck that won't be in violation of the setback.
I understand. So your house is existing, encroaching into a setback. It was built not parallel, so your plan is to put it parallel, right?
No,
Just kidding.
unless you want to change the property lines parallel.
All right, we understand what's going on. So, public hearing, is that it? The opening public hearing, is there anybody who wishes to speak for or against this? Please. Anybody online? Seeing none, I'm closing the public hearing.
Any input?
Commissioners, what is your pleasure? Any questions from Mr. Lanning?
There's no correspondence from any of the neighbors or anything, right?
No, we did not receive any correspondence.
And
I talked to the caretaker of the property,
That it would affect?
yeah, he owns like 5 or 6 lots there. The 2 next to me are vacant, and I assume he plans to keep them vacant. And the caretaker told me he didn't have a problem with it.
Sam, you said something about a driveway? Is that on that side?
Yes, that's the nearest kind of developed part of that land that he's talking about.
Perfect. Commissioners, what's your pleasure?
Based upon the foregoing findings of fact, per 54-92 and 54-66 of the Village Code, I move to grant the request variance in case PV 2023-29 with the conditions stated in the case report.
Second.
We have a motion and only 1 second. Can I get a roll call, please?
Commissioner Bowe? Aye. Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Aye.
Motion carries.
Thank you.
Good to go.
So the next item is F, conditional use request CU 2023-30. I announced that I'm going to recuse myself on this one. So Ron, you want to take the lead on this one? Or Mr. Rigsby?
Let Mr. Rigby.
Mr. Rigsby, co-chair, go ahead and take this item.
Sounds great. Thank you, Mr. Briley, or Chairman Briley. Sam, do you want to tell us about this application?
Yes, thank you. Before us, we have a request of a conditional use in a C2 Community Commercial District. It's located at 629A Sadrith Drive, Lot 15A1, Block 2 of the Palmer Gateway subdivision. As you all know, we typically require 4 or more units for it to be a traditional cabin rental. Ms. Olivas is requesting a deviation from the condition to have 4 units and only to have the single commercial cabin rental.
This is a conversion, right, of something already existing, not a new structure. Is that right?
I'll let her go ahead and explain her
Hi
case.
there.
I'm sorry.
Hello. Commissioners? No, you're not.
That's it.
You're, what's your titles? Planning and zoning
Well,
Commissioners.
depends on who's calling.
Commissioners. Thank you for hearing my case today. So this building has, the back has been developed years ago as a residential. It was, from my understanding, a warehouse years and years ago. A beautiful property. The front has, it's always been owned by the same individual. He recently sold to my client, the McLaughlin Properties LLC, and they bought it with the intention of putting it in my vacation rental. I have about 90 vacation rentals here in Ruidoso. I'm a property manager. We found out when we went to register it that the front building, which is the subject building here, is not allowed to be a vacation rental because it is C2. So unbeknownst to me as a realtor since 2015, I should have known better. And we said, well, it's next to the motels, it's C2, it's commercial. Back office, or the back residence, it's a beautiful residence. The building is actually an old house. So walking through the old house, it has a kitchen, it has bedroom, it has a bathtub. We thought, it would never occur to us it would not be allowed. So that is why we're asking for the conditional use permit. I did, through a third party, get a statement from the previous owner that he said that he used it extensively as an office rental and an overnight rental, many, many times. He said both properties were leased to private individuals on many occasions over the approximate 16 to 17 years that he was involved with the property. So with all that being said, we thought it'll make a beautiful vacation rental. And we would be managing it. My office is located, within a minute from this property. So we would always be there if there was ever any incidents or question. And there is adequate parking.
Yes, thank you. I think at this time, we'll, unless there's no questions, we'll open it up to public hearing.
I'll gavel for you.
Thank you. So thank you. At this time, we'll open it up for public hearing. Is there anybody that would like to speak for or against this conditional use? It doesn't appear so. At this time, we'll go ahead and close the public hearing. Commissioners, what questions do you have for the applicant? What comments do you have?
Who owns the house behind? Is it owned by the same person?
Yes,
Okay.
it's the intention that
And
both are going to be,
this is right next to that Sitz Mart,
yes.
right? And sandwiched in between the E's. Yeah, I actually went in that house years ago, and it is pretty cool what they did. Anybody else got questions?
No, I have a comment.
So what was the front part that we're trying to change? What was that? What has it been, or what are they using it for? Or you're saying that it used to be an old house. What did they have in there?
Well, when I looked at it, it's set up as a house.
Just set up as a house?
The previous owner was a landman, so he had dealings in real estate, and from what I understood is he would use it somewhat like I use my home office.
Okay.
Yeah.
It's a
Commissioners,
nice
other
looking
questions?
building also.
No?
Oh, you want me to?
I will.
I'm ready. You ready?
Oh, okay.
Based upon the foregoing findings of fact per 54-68 and 54-100 of the Village Code, I move to grant the requested conditional use approval for case CU 2023-30 with the conditions stated in the case report.
Second.
We have a motion and a second. Stephanie, a roll call vote?
Commissioner Bopp? Aye. Commissioner Byers?
Aye.
Commissioner Michelina?
Aye.
Commissioner Richardson?
No.
Commissioner Rigsby?
No.
Commissioner Williams?
Aye.
Okay.
Motion carries.
Thank you, Chair Rigsby.
I do also just want to state as a Realtor and past president of the Board of Realtors, I will make it my mission to make sure all the other Realtors know of this situation and that we can stop this type of thing from happening. Thank you.
It's too bad more of our rental units couldn't be in commercial areas.
All right, next item. We're going to have a site plan and concept approval case SP 2023-32. Sam, you want to give us a summary of this, please?
Well, this is slightly ironic, but Joe Yerquati is here requesting site plan approval for 4 commercial cabin rentals at 605 Carrizo Canyon Road, as you all held him to for his conditional use request previously. So this is Lot 5, Block B of the Carrizo Creek subdivision.
Welcome back.
Thank you.
So just quickly state how it's going and what you're planning to do. I see you're combining some of the cabins into, so.
Yes, first of all, pleasure seeing you all again. I do swear to tell the truth.
Yeah, we're not going to swear yet.
Starting with, we were here in September under a very similar situation and directed with lots of conditions, or several conditions, should I say, that there was no exceptions. I presented environmental, traffic, neighbors, the whole deal, and there was no consideration to a plan of 3 units on this property, right? So it kind of struggling with what just occurred, but we followed the conditions and a lot of added expense to our initial project. And Mark and I have worked, make sure that all our stuff addresses the conditions that were set by this committee. And we're here for pre-permitting review and hopefully approval with just leave it at that.
I understand. And again, we really considered the proposed, that was the whole thing that we talked about during your last presentation, is that you're building new ones as opposed to the last one and others we've had in the past, is it's an existing building, either 1 or 2 existing buildings, let us do what we need to in commercial zone. But I think because yours was build 4 or 3, that's why the conditions were put on you as such. So, any quick questions before I open the public hearing? Public hearing is open. Anybody wish to speak for or against this item? Hearing none, seeing none. I'm closing the public hearing. Commissioners, do you like what you see?
Do I have one question? Samantha, are 4 parking spots adequate?
He's required 1 per bedroom with the cabin rentals. And so how many bedrooms are in each cabin?
1.
1 bedroom in each cabin? Oh, okay. And then the larger cabin has 2?
1.
Oh, it only has 1 bedroom?
Each unit has 1.
Okay, so he would.
Yeah, so we have 4 parking spaces. We also have a carport, which would provide at least 1 more.
So the existing house, it sits on the back, it's not shown on this survey, correct?
There's no existing house.
So that's on the adjacent lot?
There's an existing shed.
It's a shed, that's right, I remember talking about that.
So how many vehicles fit under that carport? Is that a 2?
You could probably squeeze 2. Yeah, it would be tight. It's really ideally a single car and storage space.
Okay.
So the driveway that we see in this picture, is that for the neighboring lot, or is this his?
Leading into the carport.
Oh,
Parking
in that
lot.
picture, that's his.
That's yours.
That's what confused me, the building in the back was.
Oh, I see.
is
That's
on
on
Oh, no,
adjacent.
that's a neighbor, that's
Got
a
it.
neighbor's house.
All right.
We're surrounded by residential.
Yes, sir. Okay,
Mr. Chairman,
sir.
I know that they met the requirement for parking spaces, but given what we know about STRs around here, they seem to stack them in there pretty deep. Is there any way that you could fit more parking on this place? Because I foresee there's going to be more than just 4 cars in this place.
Well,
I'm just
let's
asking.
understand how we got here, okay?
Yeah, I was here last time, so I totally understand, but, I mean, you've met the requirement, I'm just
Right.
asking,
And
is
that
there?
whole driveway is almost the length of the property deep.
Right.
And it's wide enough to provide ample access parking or whatever, and still allow access for in and out.
Okay.
Is there a possibility you could maybe use the land on the north side of your property, on the north side of your property, I guess it'd be the northwest side of your property that runs along there, and then you have your proposed cabins 1 and 2. Could there be parking spot there as well, or 2? Maybe?
I mean,
Do you know what I'm saying?
my initial request was for this exact same reason, right? Is to not create a congested property
Yes,
and not turn a property that is
beautiful.
palatable to the neighbors as well as myself and turn it into a parking lot. That was my request for the 3 cabins initially. So I'm kind of confused here.
I think what I was alluding to, sir, is you've met the requirement. I'm just saying that we see it every weekend. When you rent a one-bedroom cabin, there's 3 cars show up.
Well, not on my property.
Okay, well, I hope you can hold them to that.
The whole idea for me is now with this development, I have a target audience. The couple my age or older that come to the casino for the weekend and need a place to sleep, or the person's just gonna go to grindstone fishing or skiing and not, that I don't wanna create a campground environment. I don't wanna create a family reunion environment. It'll be selective renting to individuals that just want a place to sleep and have a cup of coffee in the morning and clear out and go to the restaurant and stimulate growth in the economy.
Are you going to manage this yourself?
At this point, that is definitely an option because we do live in El Paso, so we're gonna have to have local contact and everything. And short answer, yes.
Well, I do like what you did, combine the 4 units into 2 to make it look like it's only 2, even though you're meeting a requirement of 4. I think that's inventive.
I may say, this plan incorporates some of my neighbors' concerns that I reached out to. And while they're not thrilled with me and they probably would be happy to serve me a exit plan, this is something that they can live with, but I did reach out to neighbors across and a couple down the street. They were all concerned about the idea. They don't like it, but.
And I know
tried my best.
I know your neighbors, and there's a lot of commercial going on anyway, so it's, what's the pleasure of the commission?
Yeah, sure. Go for it.
Yes, sir.
Based upon the foregoing findings of fact, the 54-67 and 54-100 of the Village Code, I move to grant the site plan and concept approval for case SP 2023-32 with the conditions stated in the case report.
Second.
We have a motion and 1 second. Can I have a roll call vote, please?
And just to clarify, Alan, you are voting on this, correct?
Of course.
Okay, I wasn't sure if you said the first one and the second.
No, I just said that one.
Commissioner Bach?
Aye.
Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Commissioner Williams?
Aye.
Motion carries.
Thank you all.
Thank you.
Sir.
Have a good night.
Thank you.
Yes, sir.
For doing your deal.
Yep.
I don't remember him passing the gavel back. Hey, it's Robert's rule. Here. He could have hijacked the meeting.
All right, so we want to stay here for a few more hours. So Sam, go ahead and take your time at Community Development Report. Since I know somebody's already picked up kids and Stephanie's too.
I don't want to take too much of your all's time. We did enclose our community development report for the month of January. I'll stay in for any questions you all may have.
Questions for Samantha? Oh, I skipped new business. Do we have any new business?
No.
So, Mr. Rigsby, are you going to be back next April for the transfer of the gavel?
This coming April or next? Who knows where I'll be.
Check in.
Yes, I will be back. I'm just here in Utah. My company, this is our big conference.
Okay,
So I'll be back next month.
excellent. Very good. Commissioners' comments?
Mr. Chairman, do we need to give our reasons for voting no on the conditional use for the one cabin rental?
Yes, we do, for the
Okay.
nay vote.
Yes.
We held everyone else to
Yeah.
the rules, and I don't know why we didn't hold ours to the same rules.
Similar reasoning as Josh. I will also say that this is a concerning trend that we're losing commercial district space because right now it is currently priced under the cabin market rate. So you can buy a small house like they did, or the other one that we heard a couple months ago for less than a residential cabin right now. And so I think it sets a precedent that we don't want to continue with, would be my reasoning.
Thank you. I do have one question for you all. We have 2 modules from Chapter 54 rewrite ready to present. Would you all like that during the regular April meeting? Would you like to do a workshop to go over those?
Workshop in May.
Or would you just like them really early? We can send them now and then give you all time for April just to bring any questions and not go through it line by line. Just send it early? Okay. We'll get those out early.
Very good. Anything else?
Oh, yeah, always.
Sam, I know our recommendations for the rezoning process, or rezoning and the definition of our different zones went to council for approval and change. I've never seen what came out of that. And I would really like to see what those new zoning laws are defined as.
Okay, just to touch base, most recently, you all rezoned 99 Sunny Slope, and the village council did approve that to go from an R1 to an M1. The intent now, as I understand, is to seek a conditional use to put a duplex on that lot to allow for higher density.
I'm not talking about that. I'm talking about when we actually sat and said, we need more homes here. And so R1, you can still have one home in a guest house. R2, now you can have 16 homes on there, 16 dwellings on there. I mean, I'd just like to see the new, how they defined it, what they left as we sent.
Oh, okay, so none of that changed. That's always been the case, that you can have 9 dwellings per acre. That's how it read. The only thing that we changed in R2 was the multifamily housing to allow a maximum of 4 units in R2. So as you all presented, they adopted that. There weren't any changes. So the R2 that we heard today was already in code. Does that make sense? Or did I answer your question?
But not as he currently has the property, right? He would have to replat it in R1 in order to do anything, or, I mean, in R2, he would still have to replat it in order to do any of that. Above and beyond 4 units, is that not correct?
So for the R2, if he was to be afforded a rezone, then he would be able to utilize the max density at 9 units an acre. And that's just the way that the code is read. If he wanted to replat that 1.87 acres into 2 separate tracts of land, then that would therefore allow him 9 units per acre. So depending how he split up those lots would determine density.
Difficult.
Man.
What's the status of the workforce housing next to the Dollar General?
It's under construction still. They are adding desks onto the units and
It looks like a
finishing the roads.
FEMA park.
Looks like a what? FEMA?
FEMA. Yeah, yeah, and this is what I commented, if this is what we're gonna get from, government housing, I don't think I'll vote for it again.
We have a 9% tax credit application in, and we'll hear preliminary at the end of this month if we're awarded that, and that'll be for apartments.
But those will be developed in conjunction with a private company, right?
Yes, we do have a developer out of California that's our partner. Mesa Apartments is what they go by in New Mexico.
I'm good.
Okay, motion to adjourn.
Yes, I moved. Second. All in favor?
Aye.
Aye, aye, aye.